Hello and welcome back. Welcome back for part two of our discussion about ethics and attorney fees. Now, I know what you're thinking. First thing you're thinking is, what happened to the television that was right about there? Well, as I think about the first half of our presentation, this phrase comes to mind: death by PowerPoint. Ever heard that slang phrase before? If there's too many slides, then the presentation is killed by the slides, by the PowerPoint. I want to make sure that doesn't happen here. So, television is out. Second thing you're probably thinking is, what's with the pub? Has McGinley been broadcasting from a pub all this time? Nope, no, I'm right here in my house. Safer at home, that's what they say. And Alice McGinley, my sister, if you're watching, you gave me that sign. I love it. I think it looks great. I'm proud to have it here as part of our broadcast. But hey, welcome back. You remember me? I'm Patrick McGinley. I'm your friendly neighborhood bar grievance defense attorney. I'm board certified in appellate practice by the Florida Bar. I'm also a member of the District of Columbia Bar. I've been practicing law for 24 years now, and it's a pleasure to teach as an adjunct law professor at my local law school for about 6 years now, including classes such as professional responsibility. So today I want to wrap up part two of our discussion of the ethics of attorney fees. And in so doing, I put aside the television. I have the folksy look of sitting here in my bar stool and hopefully giving you a great presentation. Now, you remember where we left off. We've been discussing the redundancy of ethics and attorney fees because every attorney fee question is by its nature a question of ethics. Attorney fees is an ethics situation. Fees must always be ethical. We focused our last presentation primarily upon the issues that arise with contingency fees. Now, I left you with that cliffhanger, with that burning question, with that unanswered question of, what if the fee is part contingent and part not? First and foremost, is that even ethically proper? Can you ethically have a fee that is contingent and on top of that, an additional fee that's not? The answer is yes, but it's a qualified yes. Ultimately, in your jurisdiction, there will be presumed maximums, as we went over in part one of this presentation, and your fee should not, without client waiver and judicial approval, exceed those presumed maximums, because to do so then would be presumed to be unreasonable. That does not mean that if you're working on a contingency, you can't have a hybrid situation. You can have a hybrid situation where your fee is part contingent and part not. So long as, when it's all said and done, when it's all over, when it all adds up, it still doesn't go above that threshold of reasonableness as calculated by your applicable rules. With the caveat being, the client may have a waiver and the presiding judge may approve it. But without that waiver and approval, you take the non-contingent part of the fee, you add the recovery, if any, from the contingent part, and together, if they don't exceed that cap, then cool, daddy-o, you're all set. So I left you with that cliffhanger there. Another cliffhanger I left you with, hoping you'd come on back for the answer, had to do with the family law situation. You remember, nationwide, one of the issues you always watch out for is whether you can do anything in a family law context on a contingency. Nationwide, you can never do a criminal defense case on a contingency. And nationwide, there's always something or another, sometimes everything in another, always something or another in a family law context that you can't do on a contingency. The question I left you here was, under the rules regulating the Florida bar, what was that narrow interpretation? What did the comments tell us that you could do? And what the comments tell us is this: you can work on recovery of an already liquidated claim for unpaid alimony or support. So what do I mean by that? Here's the best interpretation I can give you. If it's a fresh issue, there hasn't been an adjudication of the amount of the alimony or support, you can't do the alimony or support work on a contingency. If, however, the amount of the alimony and support that is owed has been liquidated to a dollar amount, then under the rules regulating the Florida bar, as interpreted by the official comment to the rules regulating the Florida bar 4-1.5, you can work on a contingency for that liquidated amount. So you contingency lawyers that stuck with me till now, I hope I've just answered the two cliffhangers. But as the late, great Ron Popeil would have said, but wait, there's more. Contingency lawyers, stick with me, because the rules I'm about to give you apply to everyone. And those of you who are not planning on being a contingency lawyer ever in your life, you definitely want to stay with me. Now, thanks for sticking with me until this point, because the rules I'm talking about here talk about any and all fees, contingent or not. The first rule, and you can never forget this rule, talk about reasonableness. Now, with the contingency fee, we had those presumed maximums, that percentage of recovery, and that's what equaled reasonable. Now, if we're not working on a contingency, we don't have true percentages in our rules to base reasonableness upon. But whether it's the model rule 1.5 or here in Florida, rule 4-1.5, either way, we do have somewhat of a standard to determine whether or not the fee is reasonable. The first thing I would note is under the rules regulating the Florida bar, rule 4-1.5, is an illegal fee. If the fee is illegal, then by definition, the fee is not reasonable. That's interesting that the rules say that. It's interesting when you compare it to some precedent from the Supreme Court of Florida, such as, for example, the 2016 decision of Westfall versus City of St. Petersburg from the Supreme Court of Florida. Now, irrelevant to our discussion is the fact that that was talking about a workers' compensation fee. Relevant to our discussion and to all attorneys, whether doing workers' compensation work or not, was the fact that it involved an illegal fee. Yes, indeed, Florida Statutes 440.34, as amended and as relevant to that Westfall versus City of St. Petersburg decision, provided a statutory definition for reasonable, told us under the Florida Workers' Compensation Act, by law, what was reasonable. Therefore, if you didn't meet the statutory definition of reasonable, your fee was illegal. And it was quite clear in the statute that illegal is exactly what it was, because it was a misdemeanor to accept a fee that didn't meet the statutory definition of reasonable at that time. I say at that time because the outcome of Westfall versus City of St. Petersburg was to say, ultimately, that that definition of reasonable, as applied to workers' compensation attorneys who are representing injured workers, typically they call themselves claimants attorneys, for the claimant's attorney, as applied, it was unconstitutional. The specificity or specific basis for finding unconstitutionality in Westfall versus City of St. Petersburg had to do with the state constitution. We have here, and at least 23 other states have in our state constitution, a access to courts clause. This is not a restatement of the Americans with Disabilities Act. This is instead language that has been borrowed from Magna Carta and appears in 23 different state constitutions. It has both a procedural aspect, as I talk about in my Albany Law Review article that was published last year, but it also has a substantive aspect. The substantive open courts clause, if you will, that's the phrase I coined for my Albany Law Review article. The substantive open courts clause provides substantive rights. And under Westfall versus City of St. Petersburg, that substantive open courts clause struck down the statutory definition of reasonableness. Why do I point that out? Well, the language in Rule 4-1.5 appears to defer to the statute when it says what is reasonable. But at least in that one decision of Westfall versus City of St. Petersburg, the Supreme Court of Florida is not deferring to the legislature for a definition of an illegal fee. Instead, the Supreme Court of Florida seems to be striking down legislation that makes a fee illegal if it doesn't satisfy the rules regulating the Florida bar. So, which prevails, the rules regulating the Florida bar or the statute? Hypothetically, the rules say the statute prevails. But at least in one case law precedent, Westfall versus City of St. Petersburg, the Supreme Court of Florida said that the rule prevails over the statute. Is that a right decision? Is that a wrong decision? Time will tell as additional case law precedent arises. For now, note the issue. The issue is, when is it illegal? And the unanswered question is whether or not illegality comes from a Florida statute. You would think Florida statutes tell us what's illegal under Florida law, but maybe not under Westfall versus City of St. Petersburg. Time will tell. But we do know that if somehow the fee is illegal, then the fee is unreasonable under Rule 4-1.5. If the fee is clearly excessive, then it again is a violation of Rule 4-1.5. When is a fee or cost clearly excessive? You would think that, like beauty, this would be in the eye of the beholder. But that's not necessarily a technically correct definition under the rules regulating the Florida bar, because Rule 4-1.5, subsection A, contains a subsection 1 and a subsection 2, which attempts to give us a working definition of when a fee is clearly excessive. A fee or cost is clearly excessive when, 1, after a review of the facts, a lawyer of ordinary prudence would be left with a definite and firm conviction that the fee or the cost exceeds a reasonable fee or cost for services provided to such a degree as to constitute clear overreaching or an unconscionable demand by the attorney. You know, what do you make of a definition like that? Well, one thing you could make of it is an expert witness's Job Protection Act, right? Because anybody who's trying to litigate under that particular rule, they're going to call in an expert witness, aren't they? And you would think the expert for the defense is going to say not, and the expert for the prosecution is going to say is. So one way to look at that rule is expert witnesses Job Protection Act. Another way to look at it is a litany of adjectives. You see them there? It's got to be a lawyer of ordinary prudence. It's got to be a definite and firm conviction. It's got to be exceeds a reasonable fee or cost to such a degree as to constitute a clear overreaching or an unconscionable demand. As we pile on the adjectives, I think there's only one fair conclusion to reach, that this is supposed to be a very high standard and a very difficult thing to prove, that the fee is clearly excessive, difficult to prove clear excessiveness. That, I think, is the only fair interpretation of the piling on of adjectives here. So that was option one. That was one of two ways to have a fee that's clearly excessive. Let's look at option two under Rule 4-1.5 sub A sub 2 of the rules regulating the Florida bar. A fee or cost is clearly excessive under subsection 2 when the fee or cost is sought or secured by the attorney by means of intentional misrepresentation or fraud upon the client, a non-client party, or any court as to either entitlement to or amount of the fee. So whether it's your client or a non-party or the court, if you either made an intentional misrepresentation or outright fraud about either the entitlement or the amount of the fee, then that would be something that meets the definition of a clearly excessive fee or cost under Rule 4-1.5 sub A of the rules regulating the Florida bar. I want to emphasize something I mentioned when I started this. Despite the fact that my set, if you will, here looks like a pub, this is nothing but ice water. It's all that is in this glass. That's my story. I'm sticking with it. No, that really is the truth. Look, how close can I get? It's ice water. I swear to you. Ice water. This is work. Nothing but ice water. Oh, that is refreshing. Okay, so one thing we can't have are fees or costs that are illegal. Another thing we can't have are fees or costs that are clearly excessive. Another thing we can't have are fees or costs that are prohibited. Prohibited, okay. Well, what if they're prohibited by a statute? Assuming the statute doesn't fall as it fell in Westfall versus City of St. Petersburg. Like my puns, they're very punny, aren't they? Punny puns. Assuming the statute doesn't fall like it fell in Westfall versus the City of St. Petersburg, then one way it could be prohibited is by statute or by rule. Another way it could be prohibited would be by a judicial order. Sure, you might have to be adjudicated, or you might want a waiver to be adjudicated. If either way, the judge rules no, and either no one appeals or is upheld on appeal, then it's prohibited. Charge it anyway, then you violated the rules regulating the Florida bar. And of course, you would have also have violated the model rules of professional conduct in such an instance, not just because of Rule 1.5 under the model rules, because Rule 1.5 doesn't address this. But under the model rules, I think that would fall under Model Rule 8.4. Would be a violation of Model Rule 8.4 to have been ordered by a court not to take a particular fee and then to violate that court order and take it anyway. So that's a violation of Model Rule 8.4, and it's a violation of rule regulating the Florida bar 4-1.5. Now, assuming our fee doesn't meet this purported definition of clearly excessive, we still aren't in the clear. We've still got additional analysis to do. We need to know whether the fee meets the definition of reasonable. Now, we find the definition of reasonable under the model rules 1.5, and on the other hand, we also find it in the rules regulating the Florida bar 4-1.5. When there are differences, I shall point them out to you, at least insofar as the language of the rule itself is different. When it comes to case law interpretations, that's going to vary by jurisdiction. And I will stick to the rules regulating the Florida bar when it comes to case law interpretations. So, how do you know whether the fee is reasonable? Is it a definition? Yes. It's a definition achieved by an examination of a specific list of factors. There are 8 factors under the model rules. There are A, B, C, D, E, F, G, H. 1, 2, 3, 4, 5, 6, 7, 8. There you go. There are 8 under the rules regulating the Florida bar, too. Hey, how about that? Instead of numbered, they're lettered. in the rules regulating the Florida bar. But let's take a look at the first one. This would be number 1 under the model rules over here. And this would be letter A under the Florida rules. I'll quote from the Florida rules always. First is the time and labor required, the novelty, complexity, and difficulty of the questions involved, and the skill requisite to perform the legal services properly. That's letter A under the rules regulating the Florida bar. And although I see some differences in the wording, I don't see a substantial, meaningful difference from the model rules. It appeared to me that it might be a distinction without a difference. So let's stick with Florida, shall we? And I think this will also help you on the MPRE for those of you intending to take the multi-state professional responsibility exam. So under Florida, we're talking about the time and labor required. Interestingly, if you spend more time on a case, that might imply that a higher fee is warranted, right? Think about it. Say you're able to do it quickly, lickety-split, done. That might imply that the time and labor involved was low, that the novelty, complexity, and difficulty of the questions involved were low. And therein lies the rub. When I'm involved with these fee disputes, I've been to so many fee hearings in my 24 years of practice. If the attorney has spent an ungodly amount of time on their fee petition and the listing of time entries adds up to buckets and buckets and buckets and lots of time, instead of being apologetic, often the statement is, well, this proves how difficult it was. And that's where a talented judge, using their own personal experience, and if you're litigating this, assisted by expert testimony, has to cut through the fluff, has to understand that lawyers are human. Humans have productive days and less productive days. So the mere fact that this lawyer might have spent a bucket of time on the case shouldn't in and of itself prove that the case was complex, novel, or difficult. So, word of wisdom. If you're filing the fee petition, if you're the one trying to get paid, take a look at those time entries. Keep in mind whether or not it was an unproductive day. Give the client a break. Or if you're suing for fees, give the opposing side, in fairness, the break that should be deserved if you happen to have been having an unproductive day. We're all human. We're all human. Personally, before any invoice leaves my desk, even though I may have drafted the entries and I may have already reviewed them, I'm reviewing them again. With an eye toward cuts, I'm going to reduce those entries that either I remember was an unproductive day, or maybe I don't have firm memory that it was unproductive, but as I read the description, it makes me think I really needed to spend that much time on it, and I will cut it if I can't in my own mind justify that time. Look, we're attorneys. We're professionals. We need to cut our own time. We shouldn't have to rely upon a client or a judge to cut it for us. And I'm talking about legitimate time where you actually spent the time. Of course, you don't pad your time. Of course, you don't bill more time than actually spent. Of course, you don't put down time you didn't actually do. That goes without saying. That's the golden rule. You knew that before you became a lawyer. You knew that before you went to law school. I repeat it here, but you knew that. I'm talking about genuine time that you genuinely spent, but you had an unproductive day. Cut that time too. Factor B that we weigh to determine whether it's a reasonable fee is the likelihood that the acceptance of a particular employment will preclude other employment by the lawyer. Now keep in mind, as we're going down these lists, now we're on B, we already went to A, Some of these will be yes, some of these will be no. Or to state that more specifically, some of these will be a positive factor, others will be a negative factor. We don't require a list of yeses. We don't need 8 yeses. We don't need 8 positive factors. But we make each inquiry, give it a yes or a no, determine whether it's a positive factor or a negative factor. And then at the end, we look at what positives we have and what negatives we have. That last look, after we've determined all 8 are either positive or negative, again, is not a mathematical equation. We give different weight to the 8 factors depending on the particular case. So this is both art and science. This is a balancing test, not a mathematical equation. So as we turn to B, we ask, is it a positive factor that the fee or rate of fee customarily charged in locality for legal services of a comparable or similar nature? How do we figure that out? Well, expert testimony is one way. Another way, here in Florida, I believe it's on a biannual basis, the Florida Bar spends time and money conducting a survey, a law and economics survey, and a survey that asks questions of what the professional surveyors have determined in their professional wisdom to be a representative sample of lawyers, randomly chosen, but still representative of our more than 100,000 licensed lawyers here in the state of Florida. Those who choose to answer very specific questions about the nature of their practice, the geography, where they practice, and what they are charging. So we have many years of purportedly statistically reliable surveys available on the floridabar.org website about who's charging what and where they're charging that and how much they're getting per hour. That's one source that I have used. Another source are newspaper articles. Sometimes reporters will report as to what fees are being charged in a particular locality. A Google search, a DuckDuckGo search, a Bing search, a search engine search might result in some information there. Perhaps you've seen other lawyers' bills. That's another source. Perhaps you've taken over a case that another lawyer was working on and the bill's in the file. That's another source. Perhaps a client shares with you what they paid other lawyers. That's another source. These are some of the sources to help us weigh whether it's a positive or a negative factor. Factor number 2, factor B under rules regulating the Florida Bar. That's C. C is the fee or rate of fee customarily charged in locality for legal services of a comparable or similar nature. So far we've gone through 3. We've got A, time and labor involved, including the novelty, complexity, and difficulty. Here, the more difficult case, you would hope, would warrant a positive factor, not just the case that some lawyers spent a terrific amount of time on. The second factor, factor B, was the likelihood that the acceptance of particular employment will preclude other employment by the lawyer. What's that mean? That means in order to do this work, I had to give up other work. For example, I once had, very recently, an appeal. I already had a full docket, but this new client needed an extraordinary writ. For those of you familiar with extraordinary writ practice in Florida state courts under the Florida Rules of Appellate Procedure, you don't file a notice of appeal followed by a brief after the record on appeal is created like a normal appeal. No. The writ itself is the notice of appeal. And the appendix to the writ is the record on appeal. I point that out because I was hired with just 5 days to go or 10 days to go. And in that 10 days, I had to do more than just draft a 2-page notice of appeal. I had to draft the extraordinary writ, the entire petition. I had to find, assemble, and draft the petition. I had to file it all. within that 5 or 10 days, and I already had a full workload. So I had to move my schedule. I had to contact other clients, ask their forgiveness, move their work. I had to call an opposing counsel to see if they would give me an extension of time on a discovery request. And most importantly, it was Holy Thursday. I had planned on taking the evening off. Instead, I've got playing on the video Father Rocky from, where's Father Rocky broadcast from? Relevant Radio. He's Montana, no, Michigan, Minnesota. Father Rocky, forgive me for forgetting where you are. Wisconsin, that's it. He's broadcasting in Wisconsin. Holy Thursday Mass. I really want to watch it, but I can't. It's playing in the background because I'm working on the extraordinary writ. I'm working on the appellate work. So I gave up time off. I gave up other clients' work. That's a positive factor under B, right? That's what they're talking about there. So I hope this example helps you understand what they're looking at in B. C talks about fee customarily charged. So if you're looking for $3.50 an hour, and that's what everybody charges for this kind of work, then that's a positive factor, right? If you're looking at $1,900 an hour and everybody else charges $350 an hour, then that's a negative factor, right? So that's what we're talking about in letter C. Letter D, the significance of or amounts involved in the subject matter of the representation, the responsibility involved in the representation, and the results obtained. So did you win, did you lose? That goes under letter D. The responsibility involved in the representation goes along with the amount involved in the subject matter of the representation. It's a $1 billion case. Do you have $1 billion in coverage on your errors and omission, on your malpractice, on your professional liability insurance? Did you pay more to make sure you had the $1 billion when you took on this case? That's helping to make letter D a positive factor. But you know what I've seen successfully argued? What if it's not a $1 billion case? What if it's the opposite? What if it's a nickels and dimes kind of case? I've seen successfully argued in the workers' compensation context. You know, I just obtained $800 in lost wages. They call it indemnity. They call it temporary total. They call it temporary partial for my injured worker client. But that meant the world to him and his family. It was extremely important. And then I've seen judges of compensation claims agree with that argument and find this to be a positive factor here. So the $1 billion case might lead this to be a positive factor. The nickels and dimes case might lead this to be a positive factor. Here's an interesting one. This is the fifth criteria under the model rules. This is criteria E under the rules regulating the Florida bar. The time limitations imposed by the client or by the circumstances, either one, and as between attorney and client, any additional or special time demands or requests of the attorney by the client. So in my real life story I gave earlier, where I missed out on at least paying attention to Father Rocky broadcasting the Holy Thursday Mass during the Easter Triduum, that kind of case makes this positive. What about if it's an emergency for the client? It's a temporary restraining order. It's emergency injunction. It's a thing that just can't wait according to the client. That might make this a positive factor. Likewise, what about the courts? Maybe the client can wait, but the court's calendar is a mess and the only slot you can take turns this into an emergency. That might make this a positive factor. Let's think about the sixth one. Under Rule Regulating Florida Bar 4-1.5 sub B sub 1 sub F. The nature and length of the professional relationship with the client. that can be a positive or a negative factor. I once represented a particular corporate client for 23 years. After 23 years, you get to know an organization. You get to know not only the individuals in the organization, but the culture of that organization. Compare that instead to an individual you've never met before, and you've been working for them for a week. So I think that's the balance or the analysis they're talking about here. Let's look at factor G under the rules regulating the Florida Bar, which matches up with number 7 under Model Rule 1.5, but quoting from G of Rule 4-1.5, sub B of the rules regulating the Florida Bar, there G reads as follows. The experience, reputation, diligence, and ability of the lawyer or lawyers performing the service and the skill, expertise, or efficiency of efforts reflected in the actual providing of such services. So, again, this might have to do with expert testimony. Maybe one side will offer testimony that the lawyer is a saint, whereas the other side offers testimony that the lawyer is a sinner. The reality is we're probably all a little mix of both. But let's head towards saint, shall we? And one's reputation is not always entirely within one's self-control. False rumors abound about all of us at various times during our lives. But what we're talking about here is something you might try to prove through a CV, curriculum vitae, or resume. Something you might try to prove through your past experience, your past work. That's the kind of thing we're measuring here under letter G. And the last factor under the rules regulating the Florida Bar, letter H, talks about whether the fee is fixed or contingent, and if fixed is to amount to a rate, then whether the client's ability to pay rested to any significant degree on the outcome of the representation. What are we talking about there? Talking about something close to the lodestar analysis, right? Something close to a quantum analysis. What we're talking about there is sometimes we take on greater risk of non-payment than at other times. And the rules regulating the Florida Bar, as well as the case law precedent interpreting it by the Supreme Court of Florida, acknowledge the potential for a higher fee award for cases where that risk was great, but yet payment now becomes payable. So that's what we're talking about there under H. You took the risk of non-payment, but you beat the odds and you're getting paid. Especially for those who might be able to prove that they routinely do cases where there's risk of non-payment. There is case law to suggest that those times when the lawyer actually hits and earns entitlement, he should be rewarded higher to make up for the losses. Now, that is something that the opposing side can and probably should argue against. It's not fair for this opposing counsel, OC can argue, that they should be hit with a higher fee to make up for all the losses. And that's how this particular letter H can become either a positive or a negative factor based on those sort of considerations. Ice water is refreshing, but the ice is melting. But the water still tastes good. So the question then becomes, what do you do with this A through H list of either positive or negative factors? Do you add up how many positives versus how many negatives? And that tells you the answer, no. That turns it into a mathematical equation, which is not what is intended by this balancing act. Some are highly positive. Others are just positive. Others are just barely positive. Some are highly negative. Others are just negative. Others are just barely negative. And we must weigh overall. There may be more positives, but weighing overall, the answer may be negative. There may be more negatives, but weighing overall, the answer may be positive. So what do we have? We have some bit of uncertainty at the outset, and therefore a potential for litigation. From a policy standpoint, is that what we want out of our fee rules? Do we want to encourage litigation? Well, probably not. So that might be a valid criticism of both the model rules of professional conduct and the rules regulating the Florida bar and all the other rules that are based upon the model rules of professional conduct, as the Florida bar rule is here. That could be a valid criticism. But at least we have something less amorphous than just a guess. You remember at the first unit where I began this lecture, I noted how the rules of some states, I pointed out Kansas, to be exact, the commentary says we don't use the definition of reasonableness to determine whether or not the lawyer is subject to discipline. Not all jurisdictions contain that comment. Rules regulating the Florida bar do not. But comments like that are an acknowledgement that this is more art than science. This is a balancing test. This is an imperfect way of defining an amorphous standard of reasonableness. Ultimately, though, our fees must be reasonable, whatever that happens to mean in your jurisdiction. Now, what about a cost? Florida has factors to consider there for cost. This is the factors to be considered as guides in determining reasonable cost. A is the nature and extent of the disclosure made to the client about the cost. B is whether a specific agreement exists between the lawyer and client as to the cost the client is expected to pay and how much a cost is calculated that is charged to the client. C is the actual amount charged by a third-party provider of services to the attorney. D is whether specific costs can be identified and allocated to an individual client or a reasonable basis exists to estimate the cost charged. E is in-house service to a client if the cost is an in-house charge for services. And F is the relationship and past course of conduct between the lawyer and the client. So again, we've got a balancing test. A couple of things to note. First of all, here in Florida, we, of course, have the statewide uniform guidelines for the taxation of costs. A committee of judges created the statewide uniform guidelines for taxation of costs. A quick search of the internet will find them for you. They are updated from time to time. They can be persuasive in certain instances and binding in others. For example, Florida Administrative Code Chapter 60Q-6 makes them binding upon particular adjudications at the State of Florida Division of Administrative Hearings, specifically those before the offices of the judges of compensation claims. In other tribunals, they're persuasive but not binding. In any event, they provide when a cost is charged to the non-prevailing party. They are for adjudicating in an adversarial position, adjudicating the amount of costs among adversaries and the shifting of costs to an adversary. That's the proper application of the statewide uniform guidelines of taxation of costs in Florida. But as should be clear from that reading of Rule 4-1.5, sub A, sub 2 of the rules regulating the Florida bar, the statewide uniform guidelines of taxation of costs are not controlling as to the lawyer and her client or his client. There, we've got several factors, and the actual out-of-pocket cost of the lawyer is just one of the factors to be considered. Can the Florida lawyer add a markup to the actual out-of-pocket cost paid to the third party or to the vendor or the provider of services and pass on both the cost and the markup to the client? without running afoul of the rules regulating the Florida bar? The answer is a qualified yes. Qualified because we have to factor in all A through F, but A through F certainly contemplates that it can be done. So it's not per se in Florida a violation of the rules regulating the Florida bar for the Florida lawyer to add a markup to costs when charging those costs to the Florida lawyer's client. But we have to factor in all the factors, A through F, to determine whether it's possible. Some of those factors talk about the relationship and past course of conduct. Some of those factors talk about a specific agreement. A specific agreement might reveal to the client the possibility of either a markup or an imprecision in calculating an in-house cost and turning it into a unit cost that can be added to the client's bill. Is it a violation of the rules regulating the Florida bar to include in the agreement with the Florida client a small flat fee per file or transaction to help recover overhead costs? I suggest the answer is no. It's not a per se violation, because when you factor in rules A through F, when you factor in the relationship between the lawyer and the client, the specific agreement that can exist between lawyer and client, the nature and extent of the disclosure, there is a way to ethically do that, at least with a modicum, small, flat charge. So that possibility exists. Maybe, just maybe, the state constitutional right to contract isn't violated here. Maybe there can be fairness to both the client and the lawyer here. I suggest this A through F is certainly attempting to get to that level of fairness. So all costs are subject to the test of reasonableness. When the parties have a written contract in which the method is established for charging costs, the cost charged thereunder shall be presumed reasonable, says the plain language of Rule 4-1.5, sub B, sub 2 of the rules regulating the Florida bar. In determining a reasonable fee, the time devoted to the representation and customary rate of fee need not be the sole or controlling factor, says Rule 4-1.5 sub C. But indeed, that was a redundancy, was it not? We already know that from the balancing test that we exhaustively reviewed in the definition of reasonable in Rule regulating the Florida bar 4-1.5. It goes on to say all factors set forth in this rule should be considered and may be applied in justification of a higher fee or a lower fee than that which would result from application of only the time and rate factors. The rules remind us also that contracts or agreements for attorney fees between attorney and client will ordinarily be enforceable according to the terms of those contracts or agreements. The exceptions would be if the contract or agreement is found to be illegal or obtained through advertising or solicitation, not in compliance with the rules regulating the Florida bar, or prohibited by Rule 4-1.5 for another reason, such as being clearly excessive or meeting that definition of clearly excessive. Otherwise, the rules acknowledge the right to contract and the presumption that arises under that contract. But don't forget this. There is a duty to communicate the basis or rate of the fee or the cost to your client, especially when the lawyer hasn't regularly represented the client. The basis or rate of the fee and cost have to be communicated to the client. Does it have to be in writing? No. The rules say preferably in writing, Preferably is not mandatory. Doesn't say must be in writing. Doesn't even say should be in writing. Just says preferably. That means it doesn't have to be in writing. As I mentioned earlier, can you do work on a handshake? Yes, you can. Maybe you don't want to. Maybe in certain circumstances you shouldn't. But yes, you can. Do we have a deal? Yes, you can. A fee for legal services that is non-refundable. Can there be a non-refundable fee? There can. Here's what the rules regulating the Florida Bar say about that. A fee for legal services that is non-refundable in any part, so whether it's wholly non-refundable or partially non-refundable, that has to be confirmed in writing. And that writing has to explain the intent of the parties as to the nature and amount of the non-refundable part of the fee. The test for reasonableness applies to all fees. And that's true for a non-refundable fee. What's the result of that? Circumstances could change and transform what otherwise was fairly agreed to be a non-refundable fee into a refundable fee. Circumstances could change. The case may not go, or the transaction may not go the way everyone interpreted it or intended it or contemplated it. And you've got to run that test we talked about. Clearly excessive. Remember? One of two times. It could be clearly excessive. Once, if it's an intentional misrepresentation or fraud, then it's clearly excessive. But the other one, the one that's applicable here, it's clearly excessive if after a review of the facts, remember the word after appeared there. That's why I say things could change later on. Your non-refundable fee, you might have to consider it refundable. After review of the facts, a lawyer of ordinary prudence would be left with a definite and firm conviction that the fee or the cost exceeds a reasonable fee or cost for services provided to such a degree as to constitute clear overreaching or an unconscionable demand by the attorney. So maybe it wasn't clear and unconscionable that it be non-refundable at the beginning, but circumstances changed, and after a review of the facts, now it's got to be refundable. So watch out, lawyers. You can't, even if you have fair, good faith, binding agreement at the onset that the fee is non-refundable, you can't with confidence know that it's not going to transform into a refundable fee. So watch out. Watch out and be ready and willing to turn that non-refundable fee into a refund. Yeah, it hurts your personal wallet, but it'll hurt your reputation and it'll hurt your license more to violate the rules regulating the Florida Bar. Better to hurt your wallet than to hurt either your reputation or your license. Am I right? I'm right. The fact that a contract may not be in accord with these rules is an issue between the attorney and client and a matter of professional ethics. But it's not the proper basis for an action or defense by an opposing party when fee-shifting litigation is involved. Did you know that was in the rules regulating the Florida Bar? Excuse me while I take a sip of the H2O. It's in there. It's in there. And you may need it. You may need to point it out to an opposing party if you're ever involved in a fee litigation. The fact that the contract isn't in accord with the rules, that's not the proper basis for an action or defense by an opposing party when there's fee-shifting litigation involved. So remember that rule if you ever need it. Now, when we look at the rules regulating the Florida Bar, there's more to remember. Don't forget to keep good records. Remember that 6-year rule? That applied to the closing statement, right? That applied to that statement at the end of a case. That applied to the contingency fee contract. Don't forget the 6-year rule. Don't forget the paperwork. If you're dealing in any way on a contingency, you've got to have the right paperwork. You've got to be able to produce it at the right time. Don't forget those requirements. Now, what about this issue? What about the issue that involves the waiver? Do you remember we talked about in a contingency context, and it can happen in other contexts, where the client wants to waive the cap or the limitation or the presumed reasonable percentage? How do you actually go about getting that waiver done and approved in Florida? To help you understand how the rules regulating the Florida Bar in their official commentary offer some guidance. Allow me to highlight it. The limitations may be waived upon approval by the appropriate judge, but this waiver may not be used to authorize a lawyer to charge a client a fee that would exceed the definition of reasonable, and it won't allow a lawyer to charge a fee that meets the prohibited definition of clearly excessive. So there's a limitation upon how far the waiver can go. It is contemplated, says the commentary, that this waiver provision will not be necessary except where the client wants to retain a particular lawyer to represent the client, or the case involves complex, difficult, or novel questions of law or fact that would justify a contingent fee greater than the schedule. We mentioned that earlier, but it bears repeating because it's yet another limitation about how far the waiver by the client can go. Now, you remember sometimes the fee is based on a percentage. I mentioned earlier that has to be a gross amount. But nowadays, more than ever, when it comes to larger settlements, sometimes with just medium-sized settlements, where there's a lot of liens, such as a Medicare or Medicaid set-aside, where the government wants money put aside to satisfy future medical so it doesn't become a burden upon the government. More than ever, we're seeing where cases involve payments on a structured or periodic basis. For those of you who are familiar, what is it that I'm talking about? Well, I'm talking about an annuity. I'm talking about a series of promised future payments, not necessarily promised by the plaintiff or the tortfeasor or the party, but perhaps purchased as part of the plaintiff, tortfeasor, or party's settlement, purchased from an insurance company or an annuity company or a finance company that in return is providing the annuity of this series of payments. You're seeing these more and more often. Here's the question. Say the settlement involves an annuity which over time will pay $4 million in payments. Is the gross amount percentage of the lawyer's fee calculated based on $4 million when there's not an upfront payment of $4 million? Instead, there's a series over months or years of payments that add up to $4 million? The answer is no. You don't calculate the lawyer's percentage recovery by adding up all the future payments. Instead, you reduce those future payments to their present value. And the present value calculation is what is used to determine the percentage of the lawyer's fee. The rules of ethics require this under the rules regulating Florida Bar and the official commentary to Rule 4-1.5. For those of you who are familiar with the concept of the present value of money, you know inherently that $1 today may not be worth $1 tomorrow. How do you know that? Maybe you've heard grandma or great-grandma talk about how a loaf of bread used to cost a nickel. Does a loaf of bread cost a nickel today? No, it does not. The buying power of a nickel today is less than it was in great-grandma's day. This is inflation. This is the present value of money. This is the fact that a dollar today may not have 100 cents worth of buying power tomorrow. So a stream of payments paid over years, some of those future payments, the future value of money due to inflation is not exactly 100 cents on the dollar today. So we must use the actuarially correct calculation. And that can be the subject of debate. What percentage do we use? Do we use 1%, 2%, 3% discount factor? I've seen old books that were calculating based on a 7 or 8% discount factor. Is that true today? The times they are changing. Interest rates go up and down. Inflation goes and comes, wanes and ebbs, increases and decreases. The pendulum swings. So the exact amount of the calculation varies over time. The take-home point, the lesson you need to know is you don't just add up the whole dollar amount of the series of future payments and use that for your percentage. No, 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 no. You must reduce them to present value. Another point to be made before we close has to do with the division of fees between lawyers. If lawyers that are not in the same firm are going to divide fees, the client needs to know that, and the client needs to consent. You need informed consent. Also, the sum total of all the fees can't be more simply because you divided the work between firms. That can't be the sole reason for a higher fee. That's an impermissible reason for the fee being higher than it would have been. Also, the fee should bear a relationship to the division of the work. For example, it could be proportional to the workload and responsibility of the lawyers involved. What about referral fees? Can they be paid? Yes, they're not per se impermissible, but again, they require the informed consent of the client. And in closing, I want to close with this reminder. If there's any sort of dispute, get it resolved. You're not to decide it yourself. You've got to get it adjudicated. This is particularly true if the money's in the trust account. If the money in the trust account is in dispute, that is not the time to help yourself to your fee, no matter how vehemently you believe you've earned it. If it's in dispute, get the dispute resolved. Then once resolved, you'll know that it's a permissible fee. You bared with me now for 2 full hours while I talked about the ethics of attorney fees. I hope that this has been beneficial and that you've gotten what you needed out of this lecture. Thank you so much for sticking with me. Hope to see you again in another lecture. Until that time, may God continue to bless us all. Thank you very much. Looks like when it comes to McGinley Pub, it's closing time. Thank you.